Good morning, everyone. I'm Paul Schaffino, Legislative Board Chair, and today, welcome Nancy. Glad to have you. Linda has an excused absence, Linda Clifford, who's also on the Ledge Committee. The fun of being chair, oh, and welcome to Pastor as well.
Thank you.
My travel companion. So one of the fun things about being board chair is that for a committee is that you get to spend time with the staff. And Laura and I were going over something, and I briefly this morning, so I wanted to share it with Nancy, just to give you guys a little bit of a framework. And Kurt, you smack me when I go outside of what I'm allowed to do here, which Don did a lot of, by the way, just to know what you're in for. But the framework for the legislation that we're looking at right now can get, for me, really confusing. And you know, I mean, I'm not the smartest tool in the shed, but I did have a law degree. So anyway, what we're trying, the framework we're working with all these laws is within the civil, the criminal, and the administrative arena. And where I get really confused, candidly, is where the DA, ALJ, and the AG, see, I went over that kind of too, District Attorney, the Administrative Law Judges, and the Attorney General's Office fit into this scheme. And if we remember that in our job in regulating the world of contractors, we have a mediation program, we have an arbitration program. That's what we offer as a board to help in the civil arena. But then there's the state courts, and they do their job. And we don't have anything to do with the state courts. So the state courts do their job outside of it, but we help in the civil arena, settling disputes between contractors and consumers, whether it's by mediation, which is the cheapest way to get through it, arbitration, which is a little more expensive, because some people do start hiring lawyers, state court, which costs a fortune. On the administrative side, we have our certain remedies too, and on the administrative side, we send out nasty letters for people to behave themselves. So we have our nasty letter campaign. We have suspensions of licenses. And we have revocations. Now, as you can see by this list, it's hard for us to really do much with an unlicensed contractor in this administrative arena. We can send them a letter and tell them they have to pay a fine, but we have no way to enforce it because they're really not, we have no connection to them. We don't hold their license. Under the criminal arena, we've got the DA's office. And the question is, how do we get into this world of misdemeanors? And then we start hearing about, I don't know how to spell that, forgive me, I'm sure I creamed it, but that's when we start hearing about in some of these bills that we're trying to pass, that where the misdemeanors, where we start getting into the criminal arena. So one of the things that confused me was where the AG and the ALJs fit into all this. So the district attorney is a state employee, right, that brings criminal actions against bad guys, county, that brings criminal actions against bad guys. Now, where does the ALJ and the AG fit into place? Well, the AG, the Attorney General, is the state attorney. So there, we cannot actually take away someone's license as a board. We don't have the authority to do that. We have to go to the AG. So if we want to suspend or revoke, either one?
Well, we have some provisions to automatically suspend a license under the law, but if you're going to,
so let's go
outside of those provisions or a revocation, we'll use our Deputy Attorney General.
So we can either go automatic, and that just is a trigger. So it's automatically suspended if they don't have workers' comp insurance, for example, right? Isn't that an automatic? Okay, so, or we can have a recommendation, right? And if we want to do a recommendation, that is the AG. That goes to the Attorney General.
Statement of issues, and yeah, it goes forward.
So we have to do an investigation. So there's a big investigation, goes to the AG's office, and we recommend that they revoke the license. Now the ALG steps in, because that's the due process where the contractor can then step in and say, I want to have a review by an ALJ. Is that how it works?
They can request a hearing through the Administrative Procedure Act.
So under this avenue of process, that's where the ALJ steps in, or they have an administrative law judge, and that's an evidentiary hearing.
Right.
Is that correct? where they go in front, they plead their case, don't revoke my license, I'm really not a bad guy, and this is what happened. So that's where they plead their case. All right. That really helped me understand what we're looking at. So I don't know if that helps you guys, but it sure helped me. There's my summary.
Good job.
Any questions? Okay.
Well, you know, you do also have a city attorney.
And how does the city attorney fit into that?
Well, how does the city attorney fit into that?
It's Dave Fote. The larger jurisdictions will have the city attorney prosecute the misdemeanors. LA being a good example, the LA DA will only prosecute the felonies. So, you know, many city attorneys, we want to work very closely with them because they're very aggressive in combating unlicensed practice. San Diego is another good example.
So they're kind of at the same level with the DA's office, city attorneys.
And they're misdemeanor prosecution.
Yeah.
Yeah.
You know, let me just make this more opaque, because I'm a lawyer as well. At the bottom of your chart on administrative, I just want to say that the ALJ actually issues what's called a proposed decision. So it's not actually, that decision then comes back before the registrar for adoption or rejection or whatever, but it's the ALJ after the evidentiary hearing issues actually the PD, as we know, the lingo for us in the business call it, and that comes back before the registrar. So kind of a loop.
Got it.
So if I made it more opaque, I'm sorry.
No, that helps me because that closes the circle, which I didn't. I'm still trying to figure it out as I go. All right. So forgive me my dissertation. The next item on the agenda is public comment section. This item is provided as pertaining to items on the agenda as well as items not on the agenda. However, the board cannot take any action on items not listed on the agenda. CSLB welcomes public comment on any item on the agenda, and it's the CSLB's intent to ask for public comment prior to the board taking any action on any agenda item. But if for some reason we forget to ask for public comment on an agenda item, a member of the public desiring to comment on the item should raise their hand and they will be recognized. Also, we'll be limiting public comment to 5 minutes per individual. Are there any individuals that wish to address the board at this time? Please, come on up. If you don't mind stating your name, much appreciated.
I'm business manager of Baby Terrace Construction Company. One thing I'm concerned about, and you said about the state, a lot of people have a lot of lawsuits against them. I remember many times people came to the board and said, this guy has been bad for many years. When people file lawsuits, why doesn't the contractors board check with the 57 counties here and find out which, because the contractor has to put their license on there. If they're involved in a lot of lawsuits and a lot of problems with the community, that's a big red flag. I remember one lady came here in February and she was out of pocket like $300,000. Why from the legislative standpoint, we can't track, like other states do, track contractors if they have a lot of lawsuits and have a lot of problems? Well, I mean, that's a good idea, I think.
I think it's a good idea. I'm sure there's some reasons, which I'd love to defer to our registrar to see if he can convince us.
I'll give it a shot, and then I'll hunt to Kurt. We gotta get used to this, Kurt. First of all, the filing of a suit, obviously you're innocent until proven guilty, but people file civil suits for lots of reasons that aren't violations of the contractor's B&P code section. So we're limited into what we take action on. Given the fact that if there is a suit and a judgment, we are to be notified, and we help collect the money for the person. So I think you're really asking if there's a successful suit against a contractor, should the board take action? If we are, a lot of times there are complaints filed with us and with the civil courts. Usually we do a lot faster than civil. So if it's serious enough for the board to get involved with, oftentimes we've already filed criminally or looked into it from a consumer protection standpoint before the civil case is resolved. A new law was passed recently. A lot of these civil cases had what's called confidentiality provisions where neither party could make it public. So we wouldn't even know about it at that point. That law was changed a year or two ago. The question is then, if we are made aware of a successful suit against a contractor for which a judgment was not rendered or complied with, then what is our role? We do have the ability to, if we are made aware, to look into it. But our statute of limitations may have passed. There's all sorts of things. This is a department-wide issue. It's not just the contractors board, and the law applies to all the boards in the same way. Although other boards may have specific statutory provisions that could be different. But again, to your question, if there are a lot of lawsuits, normally we're aware of them. If we are aware of them and we're not taking action, because they're not within our purview, or we've already taken action. I then asked David to correct any of the things that might have misstated, and then Kirk can do the same.
Well, I think it's important to remember that we're very effective in helping parties recover unpaid judgments through our judgment bonds suspension program. So that makes us aware of these lawsuits. We also are very aggressive in looking at the underlying reason for the lawsuit. And that's something we've implemented within the last year or so, taking a look at those consumers and why a lawsuit was filed, and are there issues that could help us support an accusation to revoke the license. To a certain extent, we are relying upon the public to make us aware of these. It would be nice if there was a central database where we were automatically notified like we are with criminal cases, but it doesn't exist today. So I would just tell you that we're doing what we can to get the word out that if you have a judgment against a contractor, it's not paid, make us aware of it. And once we become aware of it, we'll go the extra step to research court records to find out if there are other similar judgments that would help us support our action, which may be to revoke the license if justified.
Yeah, also, if they don't pay their federal taxes and EDD and they're constantly owe the state a lot of money, I mean, it's a privilege to be a contractor in the state. It's not a right, okay? And that's the other thing is if they don't pay their federal taxes, if they don't pay their EDD stuff, I'd like to see the contractors board look at developing a system on that.
If I could comment on that, we're more aggressive than ever in partnering with the Employment Development Department for the tax withholding, the Franchise Tax Board for the income taxes, and we recently received our first referral from the Board of Equalization. So you're spot on. We're trying to work with them. We're wanting this information to be out there. I don't have the statistics in front of me, but if you look at 2012, our accomplishment report, we identified over, I think it was $68 million in unreported tax withholding. And we suspended, I forget how many licenses, Karen's in the audience, you probably have the numbers, but it was like 700 licenses for somewhere close to $20 million. So can we do more if we get the referrals? Absolutely. And it's all about the relationship building and making sure that we have a seamless transition of transmission of these documents, this information to support the suspension.
Yeah, like I said about the IRS, that's easy when they can become a contractor. And the other thing is relating to legislation with continuing education. A lot of the contractors, most every profession you have, there is continuing education, and I was wondering why do not contractors have to go back to school and be current and have continuation like doctors, lawyers, teachers? Why can't people have a contractor's license also have continuing education?
Well, I'd like to refer you to our website where we have the board's policy on continuing education. I will say that neither the legislature or the governor are generally supportive of mandatory continuing education as a condition for renewal. We support continuing education. We think that should be done through the associations, but there are numerous studies that have found that the cost to the construction industry far outweighs any perceived benefits. We don't require education to get a license. Why would we require education to renew it? The costs are staggering, and the effectiveness of continuing education is questionable at best. In my personal opinion, the only people that benefit from continuing education are the providers, and you will find that it's usually the providers that sponsor the legislation to get it passed in the first place. But that is a board policy decision. Well, no, it's the governor and the legislature's policy decision, and so far, none of those three bodies support that at this time.
How about the people that have suspended licenses or Mr. Foyt does a super good job on enforcement, but how about the people that have problems with their licenses? Why can't they have mandatory, some kind of like in the military, you had EMI, extra military instruction. Why cannot the contractors who do bad that want to keep their license have some kind of remedial program to bring them back to standards?
Well, if there is part of the accusation does lend itself, the violation does lend itself to that, we have on occasion, as part of a stipulation, required continuing education if it relates to the violation. So that is something, that is a tool in our toolbox, if a course is available. Dave, is that correct, or?
Yeah, it was absolutely correct. If the contractor has a business practice that's resulted in a violation, we can have them go back and take the law exam or take courses for that. So that's part of the disciplinary process when appropriate.
Yeah, because I don't know, I have all the stuff the last 25 years the board has done, and I keep track on all the legislation, and I think it's important to keep up on things. In enforcement, it's best to enforce better, not more. People are more qualified and keep more qualified. That way you have lesser problems. But there are going to be people who are going to be just dishonest, and sometimes they're out there. But I appreciate you guys working and doing a good job on the legislation, Mr. Spino.
Thank you very much for your comments. It's appreciated. Are there any other public comments? Thank you so much. The next section is for Laura, who's going to present the Senior Scam Stopper Program.
Thank you. The first item in your packet is a report for 2013 on the Senior Scam Stopper Program. And I just want to thank our Public Affairs Division, in particular Jane Kreidler from Public Affairs, who runs this program for CSLB, in which we partner with members of the legislature to provide workshops targeted at the senior community to educate them about scams that are specifically targeted at seniors. And so Jane does a great job of partnering with members of the legislature, district attorneys' offices, other representatives to provide these seminars. So this is just a review of the schedule. I think this year we've had more senior scam stoppers than we ever have in the past. So at the end, it gives you a total. We've had 68, and then the number of attendees. And as you can see, we do them throughout the state. I think we do more in Southern California, but it's just based on the requests that we get in. So just to provide an update on how that is going and see if there are any questions or comments.
Make a comment.
Yeah.
Please.
Mr. Chair, I just want to also echo your comments, Laura. I serve as the chair of the Public Affairs Committee, and I've attended many of the sessions. And I just want to let the public know that this is a win-win, not only for us to be able to meet with legislators and their staff, but also for the public, and also for the senior centers, particularly the coordinators. They're thrilled with us being there, primarily because it's an excellent program for their seniors so that they don't get ripped off by the scammers out there. And it really gives us, the Contractors to License Board, some recognition and also some name recognition, and also people get to know our services. So it really is a win-win. I know many of the staff of the legislative office that assist us in putting these together. They're just so impressed, not only with the attendance, as you can see, is very, very good, but also with the information that is not only given by the Contractor State License Board, but the other panelists that participate there.
Thank you, Pastor, and I'd also like to, thank you for attending so many of these programs. You've, humbled me in the fact that I don't, but I think you've done a wonderful job, and you've represented the board, and you've shown to the public how important this is to us, and that's just much appreciated, because it is. It's such an important part of the program. So thank you.
Well, thank you. It's really nice when I'm able to kind of help out with the Spanish-speaking press and also, I've done a couple of them that are Spanish only, Spanish speaking only, so that's really kind of a nice thing to do. I appreciate that. Thank you.
The next item on the agenda is item D. That's the review and consideration of legislative proposals, which again, Laura's going to fill us in on as we go.
So the first item here is just a review of our 2013 legislation. It's just a status report since the legislature's out for the year. Two of our sponsored bills were signed by the governor, SB 261 and SB 262. And then we had two other sponsored bills, which are AB 993 and SB 263, which will be able to be taken up again in 2014 if the board decides to pursue these bills further. AB 993 would make some modifications to our arbitration program, and we are running into difficulty with this bill. And I think the staff is going to suggest that we not pursue this bill any further because the changes we'd be required to make to the arbitration program are significant and not something we want to undertake at this time.
So is this something, this was the, David, this is the one that you were helping Karen Hughes put together.
Yes.
And at this point, do we need any type of a formal motion to drop the pursuit of this amendment? Do we just, or this bill, do we just leave it as it is right now? What, do we need to do anything?
I don't think we need a motion on that, Kurt.
Okay.
I would suggest not. You're not exactly sure what's going to happen next when it gets back to legislature, reconvenes. I would suggest we just sort of stay the course until developments take place as they may occur.
Thank you, Kurt. Now, 262 relates to the contract state licensing law, makes the qualifying person responsible for exercising supervision, makes a violation specified construction violation grounds for disciplinary action and a misdemeanor. So 262 kicks the qualifier problem into misdemeanor criminal level.
It does provide that option. It also will allow the board to take enforcement action if we are aware that a qualifier is not exercising the responsibilities. Right now, as I understand it, if we suspect that a qualifier is not exercising direct supervision and control, we need to wait until that licensee has committed another violation of the law before we can take disciplinary action. This will allow the enforcement staff to go ahead and take action once they're aware that the qualifier is not exercising their responsibility.
So we can pursue suspension, revocation administratively, or we can refer it over to the DA or the city attorney for a misdemeanor prosecution, or both.
Yes.
Right. And then 263 amends the contract state licensing law, provides that it is a misdemeanor, again that word, for a person to act in the capacity of a contractor if they've never been licensed. Okay, so again, this kicks us into the criminal arena, and it gives us some authority to refer it in that direction.
Yes.
When somebody acts as a unlicensed contractor or acting as a contractor when their license is suspended under suspension to pay a civil penalty and such.
Yes.
Okay.
So we want to, those provisions we want to continue to pursue, but this bill originally had additional language that would have amended Business and Professions Code 7031, dealing with disgorgement. We took that language out at the request of the Senate Judiciary Committee, which had concerns about amending the law because they feel that it provides a powerful incentive for contractors to maintain their license, and they had concerns about making any changes to that. They wanted examples of problems with existing law that we were trying to solve with the proposed changes to 7031. We haven't really been able to document a lot of examples that were on topic for this. So at this point, the board needs to decide, I guess, if we want to continue to pursue the changes to 7031, try another approach, or just continue with the provisions that are left in SB 263.
Now, the last we'd spoken about that, there was going to be some type of a stakeholders meeting. Is that something we've decided not to do, Steve, or?
Well, the part of the stakeholders meeting was to get some specific examples that we could go to the committee with. We got zero. So until we asked that information from the stakeholders. So there's no there right now. I mean, it's a moot point. 7031 is not going to go anywhere next year. And you know, Laura and I have basically told industry, look, you know, if there is an issue, you need to document it. But the board, I think the board went above and beyond the call of duty to address that. And I think, again, I'll commend Cindy Christensen, who created, I think, a work of art in drafting perfect legislation, very reasonable. It's just the politics and the marketplace reality just doesn't lend itself to it. This will come back at some point in time, but it'll probably come back through industry. If we see these trends, more and more people misusing this provision of law, it will slowly percolate where the industry will probably have to revisit it. But there's no way it's going to move right now. So the author is not going to move forward with it. So it's kind of a moot point. So what we're hoping to do, is that the author will carry the other provision and drop, 7031 and fight that fight another day.
Understood. All right, so that recaps for me at least where the status is on this portion of your presentation, Laura. And then the next is, are you finished with that part, Pastor? Please.
Yeah, just a couple of questions that I had here. Since I'm new to the committee, Laura, if you could just tell me and the committee, what's the timeline here? Are we at the end of the session? Are we beginning of the session, or where are we?
We're in the middle of a 2-year session. So the legislature adjourned for the year in September, and the governor was done taking action on bills in October. So then in January, the legislature will reconvene. And so any bills that were left from this year do carry forward to next year. And then members will introduce a new batch of bills as well in January and February. Okay. And so then that'll continue on, and they'll adjourn, I think, at the end of August in 2014.
Okay. I really appreciate the summary that you provided, but I was wondering if you might be able to put it in 2 sections. Part A would be what's passed and chaptered, and the other one what's pending. Because when you start reading these, some are pending, some are enacted, and so it's kind of confusing. It'd be just a matter of cutting and paste, I guess.
Sure.
But I think it just divide into an A section pending and B chapter. I think
So
would
that's
be
good
better
feedback.
for
I'll do that for the December board meeting.
Well, okay, that would be really good. And I don't know, Mr. Chair, how you feel about whether you think we should know who sponsored this piece of legislation. I mean, I know we have that, in which committee it is, the title, the author. I don't know if that's something that we should know if there's a sponsor for that piece of legislation, whether it's an association, a labor union, or whatever it might be.
And right now, we're not providing that information?
It's not included in this. It'd be very easy. I could put it in, it's just one of the, this is a report generated by the program I used to track legislation, so I can include that as a sponsor list.
I think it'd be a wonderful
Yeah.
framework, just to kind of give us an idea where it's coming from,
Yeah,
not to
where it's
judge.
coming from,
Yeah,
absolutely.
just to-
Yeah, that would be it.
Nancy, do you agree?
Right.
All right. Laura, anything else in this section to review?
No.
Okay, so then we move on to the next section, which is for the proposed items requiring our determination as a board, I think, Laura, right? For whether or not we're going to pursue or not pursue?
Correct. So we have 4 proposals for consideration to look at sponsoring next year.
And I'd suggest we attack them perhaps one at a time, and we'll make motions or not as we go and plug our way through them. So could you
Sure.
lead the charge?
Item D1 is a proposal to amend Business and Professions Code 7011.4. We had a bill in 2011 that amended this section, and the intent of the bill was to allow all of our enforcement representatives to have the authority to issue a written notice to appear if they participate in a sting. So that was the intent of the legislation. After the bill was chaptered, it turns out, after consultations with the Department of Consumer Affairs, we need to make an additional revision to the law in order to fully implement the intent of the bill. So that is what this proposal would do, would make one additional change to the language to clarify the intent of AB 2554 from 2012, I'm sorry.
Well, it looks like they had it drafted as notwithstanding section 701, what I'm reading right here, there is in the Contract State Licensing Board a separate enforcement division, and when they put in the words "a separate enforcement division," that implied that we needed to have a different enforcement division than what we already have.
Right, it was, under this, the way the statute is written now, it was interpreted that only SWIFT ERs had the authority.
Okay. All right.
So we're trying to say that everyone has the authority.
Let's make it clear.
So this is just cleaning up the language, right?
Right.
So does that mean that we were not able to enforce this provision or the law that was enacted?
We haven't been able to fully implement AB 2554 to allow all the ERs to have that authority. Is that correct, David?
That's correct.
Now, the notice to appear is a notice to appear in court, so that is under a criminal, so that's a notice to appear over there, on that side of the chart, where it's in front of the DA or the city attorney.
Correct.
Correct.
Could I recommend that, David, can you take a moment to explain, the need for, like, what the difference between the NTAs and the ICs and SWIFT?
For approximately the last 20 years, our SWIFT unit initially was called the Unlicensed Activity Unit, which, per the legislation, would be the separate enforcement division. Had the authority to issue criminal written notices to appear for unlicensed practice. So what we're talking about here is strictly an unlicensed individual and the ability to give them a court date and have them appear to answer to unlicensed practice charges. So our SWIFT unit has had that and has worked very well. But we wanted to propose that that select trained staff in our investigative centers have the same authority. And the reason for this is it didn't seem that it's in the public's best interest that if a consumer files a complaint against you, you're issued an administrative citation. As Mr. Schifino said, there's not a real strong penalty if you don't comply with it. In fact, approximately 20% of our non-licensee administrative citations are paid. And so we want to afford our investigative center staff the ability to bring out these unlicensed contractors to stings that have harmed consumers. At the sting, they would be issued an NTA for giving the bid at the sting site, but also that consumer complaint would be packaged with the NTA from the sting, and they would both be referred to the DA for prosecution. This will benefit consumers. It provides an avenue for restitution to injured consumers. It would work very well. And the problem, though, is we've not been able to expand it to the ICs because they're not a separate enforcement division. So we just need that fixed.
All right, that was pretty clear to me. Nancy, any questions? Pastor? Do the public have any questions or comments?
Is the only change then is to delete separate and add and?
Yes.
No.
Again, any questions from the public? Any other questions from board members? Mr. Kelly?
Matt Kelly. David, will it also give them the ability to issue stop work notices?
A stop notice being administrative, we don't need the additional authority. Now, what it could do, though, is give them the authority when a stop notice is violated. Let me check that. Our NTA authority is specific to unlicensed practice, so the only way you could include a stop notice or lack of workers' comp would be as a supplemental charge when you make the referral to the DA. Our IC staff and our SWIFT staff all have the authority today to issue a stop notice to an employer that has uninsured workers.
Okay, thank you.
All right, I was doing the same counting, Joan. I think we're okay. I think we're okay. We have 7 members.
Clarify why we're having that exchange.
Oh, if we have more than, well, yeah, why don't we have Kurt do it?
Right, so there's a provision in the government code and the Open Meetings Act that talks about anytime you have a quorum, of board attending a committee hearing, the members can only act as observers and cannot participate. And it's my understanding we have 7 board members. We have 7 board members here, not 8, so we have not reached quorum level, and so those board members who are not part of this committee may participate in more than an observer role.
There's 8.
We have 8.
Frank just walked back in the room. I don't think Frank was in here. He just walked in. So I think we got lucky on the count. So with that in mind, any other further comments other than from board members that aren't sitting up here? All right, can we have a motion then, please, to amend Business Profession Code, Section 7011.4, as presented, to remove the word separate and put in the word and?
Make a motion to accept it as stated there, but delete separate and add an enforcement division.
Second.
All those in favor? Aye. All those opposed? So moved. And we'll move on to the next one, Laura.
Thank you. Item D2 would amend Business and Professions Code Section 7027.2. This deals with required content of advertisements by contractors who are not licensed by the Contractor State License Board. Under existing law, we have what's called a $500 exemption. So if you're doing work that is under $500, you don't need to be licensed by CSLB. And then existing law also allows you to advertise if you state that you are not licensed. However, under these provisions, there's no requirement tied to the dollar amount of the work. So an unlicensed contractor can advertise for work that's definitely going to be above the $500 limit, but that isn't considered a violation. So we'd like to amend the law to state that in the advertisement, it needs to state the work is under $500. And we have attached here several examples, from, I think all from Craigslist, of advertisements by unlicensed individuals for work that is clearly going to be outside the $500 exemption.
Any question from the board members? This seems like a pretty black and white effort on behalf of the board to clean up this unlicensed, possible unlicensed advertising, where they are trying to do work well beyond what they should be doing in the $500 restriction. I'm just looking at some of the items you've attached, and they're calling it handyman work that involves framing, baseboards, crown molding, sheetrock, redone restorations of bathrooms, well beyond $500 worth of work. So I think it's a wonderful statute. The only question I would have is if we have this, is to somehow present it in a fashion where we are identifying exactly where, when, and how they're supposed to put in that language. I mean font size, print size. Otherwise, they'll hide it on a separate page at the very end. If we just say that it has to be on, we have to be specific as to what we want them to say. I mean, you got to put it right underneath the initial heading. Just where it goes, how big it looks, make it prominent.
12 point.
There you go.
Okay.
There you go.
Well, one interesting observation that I made about these Craigslist ads where most of them have over 30 years of experience. And I said, well, why don't they get a license?
Yeah, right.
You know, I mean, yeah, I mean, I'm sure that something could be done, but anyway.
So based on the fact that you know, that I would like some language added to this, how would we approach that in terms of going forward with it and approving it? How would we approach that, Steve?
Could you please let staff investigate that? I mean, that's a complicated road we're going down. I don't think you want to specify font size, because then we'll be asked to take action, criminal action against someone who had a 10-point instead of 12-point.
But we could have a requirement that it's prominently displayed on the first page.
That's why I'd like to look at
ways.
alternatives
Yeah, we
and
can
come
look at
back to the
different
board.
options in the law, because there are other professions that have kind of similar requirements where it's specified in statute, so we can do some research.
We understand your
and have
intent,
options.
so we'll come back with something for the board meeting, if that's okay with you.
Perfect. So why don't we refer that one back to staff, and no motion required then.
I think the 3-day cooling off period has some language.
Yeah.
Mr. Chairman, if I may, perhaps the better course of action would be to go ahead and move it forward with the understanding that at the board meeting, you may wish to, you sort of move it forward conceptually with the understanding the question of prominently displayed and font size. Staff will do some research, and then the board can address it fully at the upcoming board meeting.
Let's do that. Thank you, Kurt. So if we could have a motion to move forward with the amendment as suggested, to be modified to include some restrictions or limitations as to where they are supposed to place this disclaimer that they are unlicensed.
I so move.
Second.
All those, we have a motion and a second. All those in favor? Aye?
Aye.
All those opposed? So moved.
Too quick for me.
Too quick? All right, so that moves us to the third item, section 711.0.5.
So this provisional law requires CSLB to take action once the Labor Commissioner submits a certified finding of a violation of the Labor Code, Section 98.9. So what we'd like to do is modify this law to make it discretionary rather than mandatory, and then delete the 30-day requirement. Right now, a lot of these referrals are sent to licensing for an automatic suspension of the law, but that is not considered to be an enforcement action, so we would like to make this change so that the way that CSLB is implementing this law is, there's not any concerns, I guess, about the way that CSLB is implementing the law, and that we're meeting the intent of taking action, but not disciplinary action, because this license suspension is not considered to be disciplinary action.
So if I could, just to clarify for my own purposes, the first paragraph in our problem summaries refers to the fact that existing statutes require that CSLB take action against licensees for specified violations of state codes. The only one that we're addressing here is this Labor Commissioner's code section. Is that correct?
Yes.
And so we don't see a problem with any others? Is this a rampant problem that crosses other statutes lines?
If I could comment on that. There's other sections of law that deal with Division of Occupational Safety and Health or other state agencies. This is specific to the Labor Commissioner, and almost all these relate to civil wage and penalty assessments where an employee hasn't been paid. And the way that we've been handling these is, for the most part, they're sent to licensing for a license suspension, but we've also taken action on many of them. And what we're really talking about here is not issuing a citation for these violations, but disclosing on our website a link that would take you over to that civil wage and penalty assessment. So what Raju talked about was the new disclosure policy we have. This information will all be available to the public. And the other part of it is the 30-day time frame to take action is unfair to contractors that are subject to a formal action. We're still going to take action on the real egregious offenders. Those are generally subject to an accusation. We need to give time to meet with these contractors to take statements from them. And 30 days is not realistic. And we've had cases that we've referred to the AG only to have them come back to us and said, you know what, you made your referral on 35 days, therefore you don't have statutory authority to do that. It should be the same for any other violation, which is 4 years from the act or omission.
So the
Counselor, please.
statutory language today is if you don't take action within 30 days, you cannot take further action.
I would argue that we still would, but some deputy attorney generals take a counter argument, and so they won't pursue our complaints. It's something that needs to be fixed.
Now, is there going to be any pushback on something like this from the fact that right now, the way we've drafted it, it says the registrar may initiate disciplinary action against the licensee. Now, we know what our intent is as a board, that certainly we would against our egregious offenders. Is there, under the way this is phrased, there's no obligation other than that we may. Should we be phrasing this where, you know, the registrar shall, in the instances of egregious violations of the Labor Commissioner's, you know, this section 98.9, is there anything that we should or could add to it to put some teeth in it so that we don't get pushback? Do we care?
Well, I'd recommend that not be put in statute. I mean, those are the kinds of things that board policies are for, and then that'd be vet through the enforcement committee. I mean, David really hit the nail on the head, though. Before, we couldn't ever disclose this information, so we had to take disciplinary action so we could put it on our website. Now, You
just
know, we
cross
put it on, now we can put it on the website. We don't have to cite or take action, so.
Because you're automatically disclosing to the public just by the cross-reference.
Correct.
Now, is the Department of Labor the only one we're going to have that cross-reference
Oh.
with? No, we're going to have it with, David, could you answer that? What other departments are we going to have this?
Well, what we hope to do is disclose actions taken by any other state or local government agency. And it's just right now putting our instructions in writing to them, because it really does solve the goal. If you believe a contractor should remain in business but should have some type of disclosure to warn the public and to curtail that type of behavior in the future, you accomplish all that by simply linking to some other website where they've already taken the action. But if we want to take them out of the marketplace, we're absolutely going to still do that based upon the criteria that we already have with the board's regulations.
Wonderful. Raju, when are we going to be ready for that? Do you have a plan? Give me a date. After Breeze, is that?
So we have Caltrans right now, for example, as well, already in the works. So we have 2 agencies that we're already doing that with, and we're continuing to work towards any other state or local departments, agencies that we could. So it's an ongoing thing as soon as we have basically all programming as far as from an IT side already done, but so the way we set it up is enforcement will let us know when something is fully available to be linked. We don't want to prematurely link something out there that's not fully, let's just say, needs to be out there. But once it is, we do have the programming kind of ready to be able to do that.
Now, do we have low-hanging fruit that we're going to pick first, David?
Yeah, what I want to mention is if you go to the internet and you look up LA County debarred contractors, it's something I showed to Raju. It's going to be the model for everyone. And I referred the address as the domain name. That may have been wrong, but what you had pointed out, Raju, is if we could get the DAs and all these other cities that have debarred contractors generally for not paying their employees or violating the public contract code, we can simply link to all of them. We only need to have that address. So Raju, if you could comment on that.
Yeah, so we need their assistance to come up with the address, meaning the URL from their side. And once they have established that, so we want to work even go out and work even with their IT staff to see if they could set up a certain URL. Once they have that, then we could link to them. So
This sounds like a relatively easy process if we just get everybody's attention.
yeah.
I think the board's a big advocate of this stuff. Okay. All right. Any other questions from the board members or from the public on this item number 3 that we're looking at? And in summary, what we're looking to do is approve the language of 7110.5 upon receipt of a certified copy of the Labor Commissioner's finding of a willful or deliberate violation of the Labor Code by a licensee pursuant to Section 98.9 of the Labor Code, the registrar may initiate, rather than the word shall, disciplinary action against the licensee, and then striking the language within 30 days of notification. Do we have a motion?
So moved.
Second.
All those in favor? Aye.
Aye.
All those opposed? So moved. Laura, if you could move on to item 4 then for us.
Okay, our last proposal, this is a more recent proposal, but what we'd like to do is establish an evidence fund. CSLB recently underwent an audit through the Department of Consumer Affairs, and one of the recommendations was to establish an evidence fund. And primarily, we would use this to pay for the procurement of our sting sites, which we pay individuals when they provide the house for the site. But under the law, the way we're paying the funds now is not in compliance with state law. So what we'd like to do is establish a fund for this purpose, which would allow us to continue to pay for the sites. So with this proposal, we have language here, but I would like to have the flexibility to further refine this if necessary. We've had one comment from legal counsel, and it might need a little bit more modification as we further develop and research this proposal.
So similar to what we did on item 2.
Yes.
7027.2.
So how much do you actually, what's the actual amount of money that is actually spent in a fiscal year? Is the 10,000 enough?
The $10,000 should be sufficient. We pay $200 for a sting site right now, David, is that correct?
It varies. We pay between $100 and $200 for a sting site, depending on how nice the house is. Yes.
Is that advertised somewhere?
Well, you're going to have about 100 stings this year, it looks like, almost. And so that would be $100 each would get you to the 10,000. So 10,000 might not even be enough if, what's her name, Jane, keeps doing her job so well, right?
So
But
that,
if that's what the staff wants, I mean, we'll support it.
we can look at that further as well then as we refine the language. I think we modeled the $10,000 on a provision that exists for another state department, but we can continue to look at that limit and see if it's possible to increase it a bit further.
I'm sorry?
That would be 100 sites at $100 a site.
At $100 a site. So, I mean, I would hate to curtail what the board's doing in these fantastic programs just because we didn't ask for 20,000 when we could have. I mean, if we're going to ask, you might as well ask once and ask for the number we need. But I would consider increasing it to 20,000 if they can get away with it. So anyway, so what we would have then, are there any other questions from the board members on this? Any questions from the public?
I don't know how this is presented, but Laura, you just made a comment that this was a result of an audit recommendation. And, you know, there's nothing in the write-up here that you provided us, I think, unless I missed it, that mentions that. And just just that this is a result of an audit recommendation, I think is very powerful in getting this thing flying through the legislature, I guess.
I'll add that to the background information. Thank
Yeah.
you.
So then, no further comment from the board, or, Steve, please.
Yeah, if you'd like to move it as amended to 20,000, I mean, if worst case scenario, 100, 200 bucks, that's 20,000. So if you want to amend it to 20.
Whatever you think.
Does that work for you, Laura? But I think you still wanted to do some other revisions, though,
Yes.
maybe, that you already had comments on, so.
But I can
so-
include the 20,000, and there may need to be a couple other modifications.
And we can approve it right now with the 20,000 plus additional, right. All I'm doing is reiterating what you just said. I'm good at that. So, right now, what we're doing is we're looking for a motion to amend the Business and Profession Code 16404.6?
That's
No.
government codes.
7017.
Yeah, Government
Okay.
Code Section 16404.6, and then as well as BNP Code Section 7017,
Correct.
adding both provisions.
And to adjust the amount from 10,000 up to 20,000
Yes.
that we'll be requesting. Do we have a motion?
So moved.
Second.
All those in favor? Aye.
Aye.
Pastor?
Yes.
All those opposed? All right, so moved. Please do so, Steve.
Yeah, I just want to remind the board members that our next board meeting is December 10th. It starts at 1 o'clock in Norwalk. The plan is for those board members that get in early enough or come in the night before, we'll visit the Norwalk staff, where they might have either a breakfast or a brunch or a lunch for us. And then the meeting will start at 1. At the beginning of the meeting, we will have between a 30 and 60-minute remembrance of Sam Abdulaziz, his family, and some of his staff will be there. We'll have, if anyone wants to speak, please let me know. I know Rick Pierce and I and Ken and Bob Alvarado's coming up, and Marky Green from Nevada is going to come over. So that's how the meeting will start. You should need to check with Aaron on your travel, whether you're going down the 9th or the 10th. The following meeting will be in the Bay Area. It's kind of split between the San Francisco airport area and downtown. Do any board members here have a real heartburn about not wanting to go to any of those places? I think we're going to try and do downtown since we haven't done that in years. Do anyone have objections to doing it downtown? Okay, we'll shoot for that, and then we'll probably look at the airport area, Burlingame or Mountain View. Those of you who want to participate in the holiday luncheons, they'll be December 10th in Norwalk and December 12th here. We'll be sending more information out. If you want to participate, please let Cindy Cindy, no. Thanks.
All right, thank you, everybody. Adjourned.
Thank you.
Thank you, Laura, much appreciated.